They came first for the opposition. Then they came for the reformers. Then they came for the judges. Then they came for the journalists. December 2006, they came for the activists, the intellectuals, the academics, and the business leaders. More than a year has passed. The trial of 40 civilian leaders in military courts continues behind closed doors. Who is left to speak out against this subversion of justice? In the early morning of December 14, 2006, 16 senior members of the Muslim Brotherhood, including 2nd Deputy Chairman Khairat al-Shater, were arrested in pre-dawn raids. They were detained without charges. Over the next several weeks, 23 Muslim brothers were added to the case. 17 men were taken into custody, while 7 others remained outside the country, bringing the total number accused to 40 individuals. The political context for this case may be traced to the 2005 Egyptian parliamentary elections. In November 2005, Muslim Brotherhood candidates running as independents found popular support in the first round of elections. The government interfered with extensive election irregularities and violence enforced by police and ruling party vigilantes in the subsequent 2 rounds of voting. Between March and July of 2006, security services detained at least 792 members of the Muslim Brotherhood. Though officially banned, the group now presents the largest political opposition in the country, holding 88 out of 454 seats in parliament.
أو السبب المباشر للمحكمة العسكرية هو صعود نجم الإخوان سياسيا بشكل غير مسبوق في التاريخ. لأول مرة الإخوان المسلمين يمثلوا في مجلس النواب 88 نائب دفعة واحدة، وكان هذا سبب كافي لإزعاج الحزب الحاكم وحكومته، لأن البديل القادم قوي ومنتشر ومتجذر وله مشروع إصلاحي وملتف من حول الناس. ففاتورة سياسية، يعني نستطيع أن نقول أن المحاكمة العسكرية الأخيرة هي سداد لفاتورة انتخابات 2005.
The case of the Muslim Brotherhood, number 963, has gained international attention for its flagrant violations of human rights. During his visit to Cairo to monitor the 3rd session of the military trial in July of 2007, former U.S. Attorney General Ramsey Clark commented, "These detentions violate the norms of both Egyptian and international law, and the detainees have suffered from the government closure of their businesses, the freezing of their assets, and the seizure of their bank accounts by the ruling government of Egypt." This case has also called the attention of Sir Ivan Lawrence, legal advisor to the Queen of England, Ali Azhar, British lawyer and chairman of the International Justice Organization, and Yvonne Ridley, British journalist and human rights activist.
الجديد في هذه المحاكمة أنها طالت الفترة الزمنية أكثر من سنة. احنا مش متعودين أن قضية تنظر أكثر من سنة. احنا دلوقتي في الشهر 13 من إجراءات المحاكمة. ده وجه. الوجه الثاني أنه جميع المنظمات الحقوقية التي استدعيناها أو التي طلبت مراقبة الإجراءات منعت من الحضور. فطبعا هم فضحوا نفسهم. يعني المحكمة صنعت لنفسها فضيحة.
The men were eventually charged with leadership in a banned organization, terrorism, and obstruction of the Constitution.
هذه القضية هي جملة من العوار القانوني. ليس فيها إجراء صحيح. ليس فيها إجراء صحيح. مثلا الضبط والتفتيش مخالف لإذن النيابة. 2. إذن النيابة صدر على محضر تحريات قاصر لا يعتمد على تحريات جدية. تم استكماله بعد القبض. المفروض أن محضر التحري سبق على القبض، لكن محضر التحري كان ينمو مع حالة القبض، وكأن القبض هو الذي يصنع التحري وليس العكس كما هو متبع في القانون.
A January ruling of the Cairo Criminal Court dismissed all charges brought by the Egyptian government against detained members of the Muslim Brotherhood on the basis of being groundless and politically motivated.
هذه القضية قضية سياسية بامتياز. أيديال، قضية نموذجية لاستعمال القانون والعنف والتسلط والسلطة والانحراف والتعسف لتصفية حسابات سياسية.
The court ordered immediate release of the men. Moments after the ruling, however, security forces disregarded the court order, detaining the men and holding them in custody until rearrest. Sarah Leah Whitson, Middle East director at Human Rights Watch, comments, "Rearresting these men moments after their acquittal shows a complete contempt for the rule of law and shocking disrespect for the court." On February 4th, the government referred the group to a military tribunal under the authority of the Emergency Law of 1958. This law authorizes the president to refer civilians to military tribunals and is used to justify arbitrary detention and restrictions on freedom of speech, association, and assembly. In response to President Mubarak's order for the case to be transferred to military court, former U.S. Attorney General Ramsey Clark comments, "What does the military court have to do with such matters? Does anyone believe that civilian courts in Egypt are unable to determine the rights of such men?" The decision was appealed to Cairo Criminal Court, which acquitted Khairat al-Shater and 11 others for the second time and ordered their immediate release from government detention. Once again, the Interior Ministry ignored the verdict and went on to hold the first session of military courts. Egypt's administrative court accepted an appeal against the president's order to refer the case to military tribunal, and in a historic ruling, the court canceled the president's decision and ordered the immediate release of all detainees. The ruling was the first in Egypt's history to cancel a presidential order. Legally, the court decision is required to take immediate effect, even if it is contested. The men were detained, however, as the government appealed the decision to a Supreme Administrative Court, and it was again reversed. More than a year since the opening of the case, court sessions continue in military tribunal. The prosecution's manipulation of charges remains heavily contested as case developments result in ambiguous and inconclusive statements. Sabhi Saleh, parliament member and defense team attorney, notes that despite recent media implications that several of the charges have been dropped, the charges themselves have not effectively changed. He explains that the suggestive diction of the charges accommodates to the political climate, loosening when pressure on the government is high during times of public protest and discontent, and tightening when government appeal improves and there's relative public inactivity. Further violations of the judicial process deny defendants the right to a trial that is public, fair, and independent. Article 169 of the Egyptian Constitution holds that sessions of courts shall be made in public unless a court decides to hold them in camera for considerations of public order or morality. Accordingly, the first session of the military tribunal declared that all hearings would be held in public and that it would not prevent anyone from attending. In reality, the court barred entrance to all means of mass media, representatives of professional syndicates, and national as well as international representatives of human rights organizations. Notable activists prevented from attending hearings include Haytham Manah, spokesman of the Arab Commission for Human Rights, Elijah Zorin, Human Rights Watch consultant and chairman of the Turkish Bar Association, Samih Karis of Amnesty International, Amar al-Kirbi, envoy from the United Nations Human Rights Committee, Ramsey Clark, former United States Attorney General, Sir Ivan Lawrence, legal advisor to the Queen of England, and Violette Daguerre, chairwoman of the Paris-based Arab Commission for Human Rights. Violette Daguerre comments, "They want to hide truth, but all the world knows very well they hold fake trials. We support them in their demands, even if we cannot monitor the sessions. We expect such military tribunals would end up with unfair judgments. These constitutional violations fit within a larger context of international human rights and judicial infringements. The African Charter on Human and People's Rights states that the only purpose of military courts shall be to determine offenses of a purely military nature committed by military personnel. The African Commission wrote, military courts should not, in any circumstances whatsoever, have jurisdiction over civilians. The case of the 40 Muslim Brothers is in direct violation of these international standards that the Egyptian government has formally endorsed. Egypt is a state party of the African Commission on Human and People's Rights, the body created to monitor implementation of the Charter, and violation of the Charter's terms presents a deliberate contradiction to Egypt's commitment. The United Nations Basic Principles on the Independence of the Judiciary requires in Principle 5 that the judiciary should decide matters without influence from other branches of government. The right to a fair trial is further affirmed by the International Covenant on Civil and Political Rights, ratified by Egypt in 1982. Article 14 reads, everyone is entitled to a public hearing by a competent, independent, and impartial tribunal established by law. In 2006, the United States government expressed concern over human rights abuses in Egypt. Official U.S. pronouncements stressed that change must come from the Egyptian people and government. In June 2006, an amendment was proposed to the U.S. Congress to cut $100 million from the U.S. aid package of $490 million in response to Egypt's poor human rights record. The amendment was defeated. In April 2006, the European Parliament voted to make respect for human rights a priority in its continuing negotiations with Egypt. In an October 2007 seminar held by the International Justice Organization in the British Parliament, contributors Sir Ivan Lawrence, a legal advisor to the Queen, and British lawyer Ali Azhar, chairman of the International Justice Organization, as well as a number of British members of Parliament, issued demands of the Egyptian government to reform mistakes in the legal system and to provide civil trials for the Muslim Brotherhood leaders transferred to the military tribunal. The drawn-out trial procedures and conditions of imprisonment pose educational and economic consequences for Egyptian society. Many of the men hold prominent roles in the academic and business spheres. Of the 33 detainees residing in Egypt, 9 are university professors, 8 are prominent businessmen, and others are notable professionals. Their arrest has raised outrage in professional communities where many of the men take central leadership roles. Public protests and vigils have been organized by the Egyptian Doctors Syndicate and the Egyptian Press Syndicate. Dr. Khalid Oda, professor of geology at Egypt's Asyut University, was arrested during his work on an international research project in Luxor, Egypt. At the time of his arrest in January of 2007, Khalid Oda was working on a collaborative project with a team of international scholars. His colleague, Dr. Marie-Pierre Aubry of Rutgers University, declares that as a prominent contributor to his field of research, Dr. Oda's arrest and the consequential delay of his projects will have effects on the Egyptian and the international geological community. The business sector also saw negative effects to this case. Parallel to the incident, more than 3.6 billion Egyptian pounds were smuggled out of Egypt as investments fled the politically unstable Egyptian market. The country's image as an international business partner is severely damaged by such situations as political disagreements overflow into industrial and business contracts without any legal justifications or any conclusive charges. Just days prior to his arrest, prominent businessman Hassan Malik had penned negotiations with the Turkish industrial group Boydak to bring foreign industrial investments to Egypt. He had signed a contract for establishing a large furniture factory in partnership with international furniture companies. 1 week before the arrest, Hassan Malik met with the Egyptian Minister of Trade and Industry and with a Turkish delegation to sign the factory contract. At the personal level, many detainees suffer deteriorating health conditions and emotional effects. On the 1-year anniversary of the arrests, families gathered to acknowledge the absence of their fathers, husbands, and sons during times of joy, grief, mourning, and celebration in the period the men have been detained. Children of the detainees suffer the consequences of dramatized house raids and arrests, drawn-out criminal proceedings and prison visits, limited income and frozen financial assets. The children responded by launching the Children for Freedom Association during Cairo's 5th International Anti-War Conference held in the Press Syndicate.
First of all, it started by itself. How it came, we went to the court, one session in the court, and the children were with us. They began to express their feelings by saying some speeches they said in front of the media, and we were astonished because they are so young and they did so by themselves, and we didn't tell them to say certain things. But they said by themselves. It was amazing, and from this we took the idea. We emerged this association to train them to express themselves in a peaceful way and to tell them a lesson that always there is a good way to express yourself.
The children held a public election amongst themselves to select a representing leader.
Although we are losing hope in this regime, we will never lose hope in change, and we don't want our children to lose hope for a peaceful and a good society.